So the topic is basically about the competition challenges of digitalization. And this is, of course, a rapidly moving subject with a lot of legislation and new decisions coming about. Digitalization changes business models, markets, and the balance of power. And the characteristics of the digital economy lead to the creation of super powerful companies that can determine how the markets work. And so the question is, what can the legislator and the enforcement agencies do about this development? And what is the perspective of consumers and of companies involved? And we have a really super panel here, incredible, and I feel really honored to moderate it. We will start our panel with Stéphanie, who could perhaps give us a status report about what the EU is doing right now.
Thank you very much, Bettina, and thank you all for inviting me to this discussion with European and American stakeholders. I'm glad to be part of this fantastic Women's at panel. So very happy to be with you. Yeah, in the last annual competition policy report, for which I was rapporteur at the European Parliament, I stressed that our competition policy was not at all adapted to tackle the current challenges. And one particular focus, of course, was on digital. Digital has gained such an importance in our daily lives. Data has become the new gold of our economy, and price finally does not mean that much online. However, our regulatory framework does not seem to be fit for purpose, as it was not designed to tackle all these new challenges. Sometimes our regulatory framework is simply not exploited enough. But as some people tend to say, like Thierry Breton, Commissioner for the Internal Market and Consumer Protection, some platforms are too big to care. And we cannot let companies, as powerful as they could be, to set their own rules to the detriment of consumers and our companies. I think Renata will also brief us on what is happening in the US, which is very interesting to see that European is not moving forward alone. Also, talking about coordination, I recalled in the annual competition report that competition policy should be better articulated with other sectoral policies, such as consumer protection, data protection, sustainable industrial, and we have to act globally in this global trend towards more coordination, which is definitely key. Competition policy will be a tool, among others, to ensure a fair competition online, but as I said, will not be enough. It will require, I think, a mix of ensuring a better enforcement of our European toolbox, adding some regulation and thinking of a new step to adapt and update our competition rule to the digital challenge. One of the key success in this digital challenge is ex-ante regulation for systemic platform that was calling in the report. And I am delighted to say that the European Union will now propose the Digital Market Act, the DMA. I think it will apparently consist in two main pillars. The first, as I mentioned previously, ex-ante rules for digital platforms, having the characteristic of gatekeepers by reference to specific criteria. The Commission should soon publish a blacklist of practices that will be forbidden, such as self-preferencing, and also a grey list that will require a case-by-case approach, since the digital markets are evolving very fast and all situations are basically different, contrary to maybe telecoms that have all the same business model. The second pillar of DMA is that a market investigation tool seem to be a new one known as the NCT, New Competition Tool for Digital Market, and I think it will examine digital markets prone to market failure. It should avoid markets to tip, and I assume that Amelia will have more to say on us further to the CMA major experience on that issue. Finally, this regulation will be the major cornerstone of our digital economy for the next 20 years, I think, and I really hope. In that sense, in that way, it has to be more efficient, agile, and future-proof. And I see two main challenges in this way, in this regard, that we have to tackle. First is the scope that has to be limited to gatekeepers platform and not to be broad. So definition of gatekeepers platform is a prerequisite with clear rules. And the second challenge is the enforcement of these rules. Once you have the regulation, you need to have a very good enforcement and enforcement tool. So these are the two definite legs, very important legs. And we need to ensure that the upcoming framework will allow the regulator to sanction properly platforms in case of infringement, but also to be fitted up with proper tools, such as broad investigation, audit, monitoring powers, including the ability to audit algorithm. However, in my opinion, and this is my last sentence, DG Comp, which is by far the most, I think, experienced authority so far in this topic, is at this stage, does not seem at this stage to have the sufficient human and financial resources to enforce properly the upcoming ex-ante regulation. Now, I think it will require more data scientists, engineers, more European resources to analyze the collected data and implement the effective and adequate remedies. But we might get back on that later, and maybe I was too long already, so I'll give the floor to my famous colleagues.
Thank you very much for this insight. I'm sorry for coughing. I will pass on to Vanessa, who can perhaps give us an insight on the BEUC's perspective.
Thank you, Bettina, and thank you to Women App for the invitation to speak today from the consumer perspective. So Stéphanie has set out very nicely what it looks like the DMA will consist of. There are lots of sort of hints in various speeches and various documents that are floating around, so we may not be entirely sure of what's in there, but on the basis of what's out there, I would say what we've seen has some very good points and some less good points and maybe some unclear points from the consumer perspective. Good points are, as Stéphanie already mentioned, the special ex-ante rules for gatekeepers, so asymmetric regulation rather than some of the other options rather, that were in the DSA consultation. Secondly, and I think very important from the consumer perspective, is the idea to have self-executing do's and don'ts, or black and white lists as they've been called, because these are likely to be the quickest way to have an effect on the market and prevent harm to consumers in the form of reduced choice and reduced innovation. Third good point is, but I'll come back to this under the bad points as well, the market investigation tool to tackle market failures and to prevent new failures. And I think fourth good point is that with the DMA, we seem to have a slightly more coherent whole than the two separate proposals that we had initially in the consultations in the form of the DSA ex-ante regulation and the new competition tool, the NCT. But that brings me then on to my less good points. It seems from what we've heard that a horizontal new competition tool has been abandoned by the Commission's proposal, and this despite the fact that actually the majority of people in the consultation backed a horizontal NCT, and we now have one that is looking only at the digital economy. And again, it may be to be seen, but the scope of this tool may be diminished to certain areas. I hear 4 areas, although different things at different times, of within the digital economy. Now, picking up a point that Stéphanie raised, I hope that's not the case, because if you limit the scope of that tool to only certain areas of the digital economy, that seems to me that there is a danger of it not being future-proofed. And clearly, while digital markets are very important for consumers, in a way, this is a wasted opportunity by not doing a horizontal NCT, it's a wasted opportunity to deal with competition harms to consumers across other markets, because they don't just exist in in digital. So having dealt with the good and the bad, what about the unclear? Stephanie mentioned also that in addition to the black and white list, we have a grey list. How this will work, other than it's case by case, is not entirely clear to me yet. I've seen references to unfair practices where intervention is required by a regulator. Now, I have to see what that means. To me, that doesn't sound like the classic competition restriction and efficiencies analysis, but I guess we'll see when further details come out for that. Then, likewise, as Stephanie mentioned, enforcement is going to be absolutely key in whether this DMA is a success or not. In our view, given the nature of the digital economy and the power of the players and the potential impact on their business model, enforcement at EU level would be extremely important, and also better global coordination. This could be some kind of ECN type case allocation model if it's not purely at EC level, but it would be logical for the EU level to be the kind of default level unless some national authority would be better placed to deal with a specific issue. And also, as Stephanie said, whoever does this, and probably ideally the Commission, needs to have the resources, be properly resourced in terms of finance, but in particular also in terms of expertise. And I would fully agree we need to have data scientists and behavioural economists to make sure that this regime actually works. And I think it would be important for whoever's doing this enforcement to work with other relevant agencies, in particular data protection agencies. And then finally, again, very similar to what Stephanie said, we think from the consumer angle, it's going to be absolutely critical to have proper sanctions and processes to make sure that the rules that are foreseen in this DMA are complied with. And finally, to have a clear and regular review mechanism to make sure that the identity of gatekeepers and the do's and don'ts lists are kept up to date. Otherwise, the regulation risks being useful for a while, but not for the 20 years that Stephanie said we should have it for. So we hope that they'll all be in there, all those points, and I'll leave it there.
Okay, thank you very much. Stéphanie, would you like to add comments, or should I move on to Amelia?
Oh, please go ahead with the other panelists, and I'm really glad, and I do agree, and I echo what Vanessa just said. Okay,
Amelia?
So I think you wanted me to talk about the UK, what's happening in the UK. I should just emphasise that although I am a board member at the CMA, I'm not speaking for the CMA, I'm speaking with my academic hat on. I would also just emphasise that the CMA, of course, already has the market investigation tool that is applicable broadly, not just to digital markets. And therefore, I'm not going to really talk about that because that's something we already have. There are some recommendations bubbling around for changes, small changes to make that tool more effective, particularly around flexibility of remedies. But basically, we think it's a good tool. If anything, we should just be using it a little more. But in terms of what else is happening in digital, I mean, in a way, I feel kind of culpable for kicking all this off because I think the Furman report, which I was involved in, was the first report that kind of said out loud that antitrust wasn't really sufficient in this space to address all the issues and that we really needed digital regulation. And I'm obviously, I'm pleased that we kind of kicked off that debate and that we've got here so incredibly fast. At this point, the UK is in danger of being overtaken, at least by the EU and maybe some other jurisdictions, but I hope that we will keep up. So the CMA recommended the ex-ante regulation, also recommended a change standard for merger review, which I don't know if we're going to talk about much today, but it's just worth flagging, and also recommended that the CMA investigate the digital advertising market, which it has since done. And just echoing something that Stephanie said about the need to work as far as possible on a global basis. And this is the reason that these kind of conversations are so great. we had a whole chapter in the Furman report about the importance of thinking about these issues globally so far as is possible, and the need to work interactively, because these are big global companies, and it's actually only fair to them if we can have as consistent and coherent a regulatory and antitrust and consumer policy and privacy policy framework for them to act within. That will be best for them. It'll also be best for consumers. It's a hard thing to achieve, but I do think that as much talking across jurisdictions as possible, at the very least, is valuable. The UK government accepted, in theory, the recommendation for digital regulation, although it was the previous UK government, same party but different government. But they created a digital task force to provide them with advice on what this might look like. And that's looking at issues like what would the criteria be for for designating a platform as having strategic market status, and therefore being covered by the code of conduct within the regulation. So that's being looked at the moment. Another thing that's being looked at is how the enforcement setup would work, as an echoing Stephanie's point. I mean, it is clear that actually what you want is a setup where you have as much participative engagement with the parties and all stakeholders as possible, because these are very complex markets, difficult and complex issues. So trying to talk as much as possible is clearly going to be best in terms of not unduly inhibiting innovation and competition, but equally you've got to give some incentive for that participative engagement to occur and be constructive. So in the end, I think you do have to have some real sanctions at least there as a stick, maybe never used, but there as a stick. So that task force is going to deliver it has to deliver by December, so we should see very soon what they're going to say. The CMA isn't quite as leaky, or in fact it's not really very leaky at all compared to the European Commission, so I'm not going to be the person that leaks, but the stuff will come out soon. What the CMA has done in the meantime is it has published its digital advertising market study, and actually what that contains is an awful lot of detail about at least looking at the two main platforms in digital advertising, so Facebook and Google, and looking at those particular activities associated with digital advertising. So they don't look at the Google App Store, Google Play, for example, but they look at digital advertising aspects of Google. They set out what they would think for those two players digital regulation would look like, and essentially what they think is they would have, if these two players were designated, which broadly it considers they should be, without saying what the criteria would be, there would be a code of conduct with some overarching objectives, and then under that some more granular but still pretty high level principles. And in fact the report proposes, but I think there's a lot of discussion still to be had around these, proposes 17 principles. And I think there hasn't actually, to my mind, been enough debate around the substance of those principles that have been set out. There's a different set of principles in a recent paper by Philip Marsden and Ruprecht Podsen, which are similar but different. And I think that there needs to be more discussion around converging to the right set of principles. I can't promise that the CMA will be delivering that, because that would be in turn for the regulator to set out what those principles would be. The other aspect, which is a bit different to the European proposal, is, as well as the code of conduct, which would be clear principles, kind of this black and white list. We also there's also a recommendation to have pro-competitive powers, which would allow the regulator to intervene, having done a bit more market analysis, but where it feels it's proportionate to, in order to create a market design, market structure in which competition is going to work effectively. And the sorts of remedies there might be data separation, data access, data mobility interventions, requirements around the choice architecture for consumers, for example, around privacy consents, and even more structural powers. Those would potentially be applicable to firms that were not designated as SMS. Because actually, if you think about things like data mobility and interoperability and standard setting, if you're going to create a market that works effectively, they have to apply right across the market. It's actually not good enough. If you think about number portability, it wouldn't have been sufficient to give number portability and put it only on the dominant telecoms companies, because people would still have been scared of switching in case they then wanted to switch back and they would lose their number. So you've got to have number portability across the market for the competition to work effectively. And so that, I think, is an area where we're recommending slight difference to Europe. I'll leave it there.
So I think I'm next, jumping in on the US. If it looks like I haven't slept, that's because I really haven't slept. And I was going to make a joke about how there's nothing going on in the US right now. It's just, smooth sailing, everything's fine. Nobody needs to worry about anything. I feel a little bit like the Wizard of Oz, nothing to see here, nothing to see here. So hopefully we'll have a president soon. And probably people can guess which candidate I'm hoping for a victory on, but we don't need to go there. So there's obviously been a lot going on here on the antitrust front, which is, I know, what everybody wants me to talk about. Just a few things. I mean, we have this months-long investigation that went on in the House subcommittee, which resulted in a very, very lengthy report in October. Excuse me. With some legislative proposals, I would say quite far-reaching in terms of their scope, but also with a kind of a minority report coming along with that from Representative Buck, that I think for me was actually probably the most interesting thing about what happened there, which was that there was some bipartisan consensus, at least on the Hill. Someone told me I needed to be very careful to say that there was not necessarily bipartisan consensus amongst the antitrust agencies, but bipartisan consensus on the Hill that something needs to be done. And obviously, if you look at the minority report and the majority report, there are differences between what they propose, but I think that middle ground and that area where there is consensus, I think, is likely to be the place where you will actually see some legislation develop. And it won't, in my view, it's not likely to be as far-reaching as the minority report. Although, again, depending on what happens in the election today, maybe the Democrats take the Senate and they'll be able to push more of what was in the majority report through. Easy consensus points, additional resources for antitrust enforcers. In the US, I mean, people think this is kind of a funny thing to say, that the enforcers are under-resourced. Everybody says it's the US government, how could it be under-resourced? But over the last 10 to 15 years, the agencies really have been drained significantly of resources. So fewer people, and just fewer, at least if you adjust them for inflation, fewer dollars to make use of. And I think there is a real consensus that that the agencies, in order to be able to tackle these significant problems, that the agencies need more resources. That's something that seems to me to be true and a fairly easy fix. The transferability of data between platforms, that's been another topic that people have talked a lot about, that if consumers can't move their data from one platform to another, that makes it very difficult to switch, and it ties people to the platform that they're on. We saw this with mobile telephones, and number portability really, I think, did a lot to break open competition in that market. So it seems natural that that would be something that people would be talking about and thinking about. It's interesting because we don't have privacy legislation, federal privacy legislation in the U.S. right now, which is a big gap. And so I think there hasn't been a lot of legislative focus on, or legislative guidance, put differently, on data and how data can be used and what you can do with it. So my hope is that if there is going to be legislation around data portability, that would come in the context of actually doing a little bit more with privacy and other issues that arise with data. Interestingly, the minority report also talks about shifting the burden of proof in merger cases to make it easier for the antitrust agencies to bring successful merger challenges. That's a pretty big proposal. And the fact that it's in this Republican-led report, now granted it's only three or four, I can't remember, 3 or 4 Republican House members, but that's, I think that's a fairly significant proposal. And then there were a bunch of areas where the minority report talked about needing to do more investigation. So leveraging monopoly power from one market to another. That doesn't strike me as new in an antitrust theory sense, but maybe there's legislation that could be written to make that easier. Predatory pricing, that's an area which has been rife with complication in the US. So could be interesting to see some legislation around that. I mean, to be clear, the minority is saying we should study these issues more and get more experts engaged on that. That does seem like an area that's worth looking at. Revitalizing the essential facilities doctrine. That's another pretty surprising one. In the U.S., we've thought the essential facilities doctrine in the U.S. was pretty much dead. So the fact that people are suggesting that maybe we should rethink and look at that and look at whether or not this almost enforced dealing should be something that we should consider. That's interesting. This is another area, refusals to deal, that the U.S. has been, for a long period of time has said, we don't force competitors to deal with their with other competitors. The essentials facility doctrine essentially, if it went forward, would say, yes, you do actually. Sometimes you do have to let a train go over that bridge because that bridge is the only way to get from one place to another. And then interestingly, the last one is, how platform monopolies should be allowed to make design changes to their services. That one I find somewhat puzzling, and I'm not exactly sure what they're thinking about there. Having worked on the Microsoft case when I was at DOJ many years ago, and we spent a lot of time working with Microsoft to try to figure out how to have an interface where users could choose which defaults to set. I have to say it felt a little odd to be spending time on Microsoft's campus talking to them about how to design their software, but we'll see what comes of that. So that's the legislative side. I do think the, kind of how the election ends up coming out is going to probably drive a reasonable amount of how far any of these proposals go, but so that remains to be seen. And then, of course, we have the lawsuit that was filed by DOJ against Google. It's an interesting case. I think people were expecting something unusual in that lawsuit. And if you read it, it really is a pretty straight down the middle monopoly maintenance case based on exclusionary agreements. That reads, it doesn't read exactly like the Microsoft complaint, because I don't actually think that the documents that they quote are as good as the ones that the division found in the in the Microsoft case. There's no, cut off their air supply kind of documents that we found in Microsoft, but it's a pretty straight up exclusionary conduct case, which I think makes sense, and we will see how that comes out. So other than that, there's not much going on here.
That seems already quite a lot. Thank you very much. We will probably go into more detail later on when we cover the different aspects of the DMA and what you said. I will turn to Karen now, because perhaps she might give us an opinion of what the company's perspective is, because actually booking might be one of the regulated companies, at least theoretically.
Thank you, Bettina. Yes, I would very much welcome, in addition to what the other panelists have already said, from Booking.com's perspective, indeed not just any company's perspective, but very much, well, a platform ourselves, but also, again, a business user of other platforms. For us, we're following this very closely, have also actively contributed to the development, I think a few things I would like to say to the topic. What I can broadly say, as to also how Stéphanie outlined the proposals and what is known to date, is that we, and also how the DMA will be structured, is that we have a strong support for a broad market structure-based new competition tool and a very targeted gatekeeper regulation addressing the recurring anti-competitive behavior. And I fully support the comments made before as to who they should actually enforce these rules. We actually think it should be enforced by one agency across Europe. Most logically, an experienced agency like DG Comp. So I echo what Stéphanie and Vanessa already mentioned in detail on this. By having a broad NCT and a very narrow gatekeeper regulation, we actually believe that only in that way it can be assured that the rules and regulations are targeted and proportionate, and there's an overlap will be avoided between these two instruments, and in addition complementary to competition law. And we also believe that in that way innovation and dynamic markets are fostered, competition on the merits remains, and that this will ensure consistency and a uniform application of EU competition law. I also very much welcome Amelia's comments that it's only fair for global players to also ensure that there's cooperation and consistency beyond the EU with the UK proposals and initiatives very much to be streamlined, but also in other areas of the world where similar initiatives are being deployed. And also not just across jurisdictions, but also across disciplines and alignment with consumer law and data privacy. So I'll just go into a bit more as to the reasons what Booking.com's viewpoint is, and actually why we believe there's a broad NCT that should be applied, should be applicable, and what it should look like. We actually think that it should only apply in situations where there are structural risks for competition or structural lack of competition. And I very much, we very much welcome that this would be also broader than just digital markets, but apply to all sectors equally. And it's flexible enough because it's a case-by-case approach and have an upfront market inquiry. And to turn on, there's a few more other elements, but I'll also just highlight why we actually believe there's a narrow gatekeeper platform regulation needed. And as Bettina already mentioned, otherwise it would actually risk other companies unnecessarily being dragged into this. So what has been outlined or known so far, indeed, to have a list of prohibited practices for gatekeeper platforms. But then it is actually very important. It all comes down, and also when these initiatives are being finalized and close to be announced early December, how you actually define a gatekeeper. And the main characteristic we believe is that it is a company or a platform defined by single homing by consumers or business users. And then very much so, we believe as Booking.com that is definitely not applicable to us. We're actually a multi-sided transaction platform whereby both business users, multi-home, they use a range of different ways to actually distribute their inventory, and consumers multi-home as well, and use a variety of platforms to actually search and make their booking. For us also, I mentioned what we actually think the main focus should be of the gatekeeper regulation should actually be on the self-preferencing by vertically integrated platforms. So that's it from our view.
Okay, thank you very much. Any questions or comments from the other panelists?
Just one other thing, which I meant to say before, but I think fits in with part of what everybody's been saying, and we can talk about it more later, is that there is this phenomenon of authorities all over the world approaching these issues and potentially approaching them differently. And I do feel like that could lead to a very uncomfortable situation. I'd be interested in Karen's views on this, because for companies having, I mean, it's sort of like the merger enforcement regime where you have to file in 20 different places and they have different filing thresholds and outcomes are different, and even if the markets function the same. When we have these global digital markets, finding a way to bring some coherence to the regulatory scheme, whatever develops across jurisdictions, seems to me to be an important thing for people to at least bear in mind and think about as they move forward with these proposals.
And I recognise that Brexit doesn't help with one aspect of that. I was just going to say on that front that it was interesting when Renata was talking about the changes to, or the recommended changes to US antitrust. I'm not a law scholar, and I'm sure there are law scholars looking at exactly this question, but it would be interesting to know how much that is simply, well, how much that is moving US antitrust practice essentially to where the EU already is, because a lot of those concepts have been more utilized in the EU than they have been in the US. So at least in that space, if that goes through, we could see a bit more convergence there, I think.
I think that's right, Amelia. These are concepts that are, have, as I said, have sort of been dead in the U.S. Over a period of time with judicial changes and frankly a lack of legislation to build out what these very broad statutes mean, and Europe has moved ahead. I think there's a debate in the U.S. whether the European way is the right way to do it. I've often wanted an economist to do a study asking the question of whether or not a more hands-off regulatory regime, like as we have in the U.S., actually does in fact lead to more innovation and more technological change. That's a kind of one of those things that people in the US always say is true. It's something that I've believed is true, but I've never actually seen anybody do a study. And it feels like to me like something an economist could actually spend a lot of time with, the great PhD project maybe, to figure out whether there's a way to actually measure that. Because one of the things that I hear when I'm in Europe, and I do wish I were in Brussels right now, is that why don't this question of why don't we have a Google? Why don't we have an Amazon? Why don't we have a Facebook? Why has that kind of development not occurred in Europe in the way that it has in the US? And I think the kind of reflexive US answer to that is, well, because you have a more, then this is just, it's been this way. You are more comfortable with a more regulatory approach to markets than the US has been, at least in the last 50 to 60 years. Is that right? I think it'd be interesting to actually know the answer to that question. And that, I think if you knew the answer to that question, that would really help all of us figure out what is the right path here? How should we navigate this?
Actually, I personally don't think this is right. don't think that regulation is an inhibitor. I think there are other factors. What do you think, Amelia?
I think it's an extraordinarily hard question to ask because I think there's so many other factors going on. So I don't think I'm sad that I don't think any PhD student's going to answer your question.
I just have a question from the audience. Wait a second. I can't handle it right now because it's too much text, actually. I will read it in the meantime and see what we can do about it. By the way, this was more or less the general question where we are. And there are in total 4 detailed points that we could cover, which are part of the general discussion. The first is, what will we do with data? And this has 2 aspects. It first has the aspect of data ownership and who can access data. And this is perhaps something Stéphanie could talk about, because this has to do, for instance, with the question of whether the essential facilities doctrine should apply to data. And the other aspect is actually consumer protection, because data ownership always has to do with data protection in the end. So Stéphanie, would you like to start?
Yeah, thank you very much. And actually, that's a good link with what I wanted to say as a reaction to what Renata said on revitalizing the essential facility doctrine in the US. As I've said, data is the new oil of the economy and maybe of the whole society. And one of the main challenges is to allow access to key inputs, such as data, of course, and essential online infrastructure. Therefore, I think we should, and it's really the way we see things in the EU with the Parliament. We should update, and not only the Parliament, but we should update our theory on essential facilities. It's, of course, easy to assess that was echoing what Renata said. It's always easy to assess that a port infrastructure could be an essential facility, but it's more tricky with data. So far, the 5 conditions of case law are hard to be met. And that's why, in our case, I think applying the essential facility doctrine to data requires a detailed case-by-case assessment or whether or not a data set is a truly essential. It is therefore not possible, I think, to say that in general data or personal data is an essential facility, or at this stage I don't really have the criteria or any input on that. I just recall that last year in 2019, Olivier Gerson was newly at the State Director General of DGCOM, suggested that large digital platforms should be considered as essential facilities and that they should be treated as such. And at this time, the Commission further explained that he was referring to essential facilities in the context of possible legislative initiatives, mentioning notably the regulatory framework applicable to the railway. He indicated that a debate should take place about whether similar regulatory obligation should be enacted vis-à-vis digital platforms. And I think it is in that context that the legislator would need to maybe know or identify the relevant criteria and maybe threshold, which would trigger the application of specific regulatory obligation. And I think this is now the case with the Digital Market Act that will only target gatekeepers platforms. But as I said, there can be no general approach of applying this so-called essential facility doctrine to dominant digital platforms. And in addition, I think the essential facility doctrine is just one of the possible theories of harm which the Commission can apply, notably when assessing the legality of a conduct consisting in a refusal to give access to a facility which is deemed to be essential. And within the DMA, one possible remedy that could be in use in some cases, depending on the situation, would be the opening of data to allow competition and interoperability and data sharing, of course. And Renata mentioned the issue of transferability of data between platforms, which is definitely key in this respect as well.
What's interesting, me personally, for instance, is what the issue of financial data. For instance, when you look at index data, some companies need access to these data for their own business, and you also have the question of interoperability. For instance, like in the Thomson Reuters case, just as examples. Perhaps, Amelia, would you like to add something to the data question?
Yeah, so I mean, we in the UK end up thinking very much about essential facilities doctrine because we reached for the regulatory approach instead. And one of the reasons for that is it didn't feel that denying access to your proprietary data to a competitor felt like the kind of thing you should necessarily face an enormous sanction for, because there's lots of proprietary data bubbling around, but that it was the kind of thing where when you looked at proprietary data, you might well consider it proportionate to require access to that data in order to drive competition. And there's a slightly different thing about really the culpability and the clarity of whether there's been kind of strategic bad behavior. I mean, I'm sure there will be situations where essential facilities doctrine may be relevant. So, for example, if you have been giving data and then you refuse it, that might be seen as a somewhat different situation. So we recommended that one of the things that the regulator should be able to do is require access to data in a couple of different ways. One is obviously the data portability point. So they should be able to require that APIs are set up so that data can be shared with third parties at the consumer's request, and very much it kind of reflecting what we've already done in the UK in open banking. It's not straightforward to set up these APIs, as has been suggested. You've really got to set up, it's complex to make these things, infrastructures really work effectively. Another reason why actually getting the regulator involved is a good idea to oversee it. So that's one area, is data portability. And in fact, the market study comes out as saying that one particular area where data portability should be looked at further by the regulator is in the area of social networks and the ability to take your social profile to another social network to make switching, or actually importantly, multi-homing. We've heard about single homing and multi-homing. The more multi-homing you can have, the less likely markets are to tip to monopoly, then the less the market power issues are likely to be. And therefore, actually this data portability, if it's on an ongoing basis, that you're literally your data is consistently being shared between two platforms, that can actually be really good for driving competition through multi-homing as well as through switching. The other area that the market study looked at was this idea of pure data access. And the particular thing it looked at was Google's search and switch data. And it's heard from people like Microsoft, massive companies, who were really struggling to compete against the Google search offering because the extent of the search and switch data allowed the ever better provision of search by Google, and that market has essentially, there was concern that market had tipped, and so the question was, should access to that data be provided to competitors so they too can improve their search service and compete more effectively with Google in providing a search service. So that's something that's been left for the digital regulator. And the final thing here, so there was a point there about you can, to some extent, there's always this balance with privacy. So if you give consumer data, are you infringing their privacy? And there are ways to do that. So you can give access to data without handing data over, for example. So I think there's going to need to be more thoughts about how you can allow kind of bots in to learn from data without actually ever transferring the data and losing control of it, in order to respect that privacy angle. The final thing that the market study looked at was whether Google was actually taking an overly narrow approach to, and Facebook actually, an overly narrow approach to the application of GDPR in not allowing its third parties to access data, even data that was less sensitive. And they didn't reach a firm view on whether they were, but they felt that another thing to be looked at further. But that basically they were being over cautious relative to what the GDPR required, and that was having anti-competitive effect.
There is a question from the audience which might fit in here. This has to do with the relation between regulation and innovation, basically. And I think you can really apply this to the data question, because of course the collection of data also has to do with innovation and the power of your service. And if you have to give these data to your competitors, you might be less willing to invest. So what would you think about this?
Well, I agree that that's something you have to trade off and be really careful about, which is why you don't want to intervene willy-nilly. And actually one of the reasons I slightly worry about weakening the essential facilities doctrine too much, and think it's better to take a proportionate case-by-case approach.
Okay. Vanessa, would you like to add something on the consumer perspective in this context, data, etc.?
Yes, thank you. So, I mean, in some ways, the essential facilities doctrine would be a logical way to look at data access under competition law. But and as said by some other people, I wonder actually how often it's going to be relevant, because how often are you going to have data being unavailable elsewhere or not replicable? And I was going to say, I can think of one example, but Amelia's already mentioned it, and that would be the Google click data in search. There may be other niche areas, and these may not fall within the gatekeeper regulation. One that springs to mind, potentially anyway, is some types of in-vehicle data in relation to connected cars. I can think of some where you could, like type approval regulation data, where you need that for repairs in order to foster competition, you might need access to that data. On the other hand, geolocation data for cars probably is not falling into the same category, because you could get that via mobile phones, for example. So there's certainly some ideas we could pursue there, but they may not be the be-all and end-all of data access. I mean, certainly one can think also of other competition principles that could apply to deal with data problems resulting from gatekeeper-style conduct, be it discrimination or tying or things like that. And as I think, Amelia, you mentioned already as well, I mean, if regulation is being adopted, it does not necessarily need to be limited only to competition law principles, and one could see that regulation could also be based on business and consumer rights type of principles. And there, as others have mentioned, one of the key things I think in terms for consumers is in particular data protection. Because I think we need to think about data in multiple ways. I mean, data is an output, financial data, as Bettina mentioned. It's an input for innovation. It's also, you could look at it as a counter performance or a currency when consumers are giving their data to platforms. But very importantly, in the European Union, the processing of personal data also has a fundamental right dimension, because privacy and personal data are protected by the EU Charter of Fundamental Rights. So data is quite complicated in the sense that it's not only an economic value. So any kind of regulation from the consumer perspective needs to reflect those sort of multiple facets of data. Rather than maybe go in some other kind of more competition solutions that other people have already discussed, maybe just focusing a bit further on the protection of consumers and the idea of that getting in the way, or sorry, privacy getting in the way of data access. Sometimes it is argued that they're hard to reconcile. So data protection, preventing data access, thereby strengthening incumbents and hindering innovators, as Amelia touched on. And it's certainly true that the European GDPR imposes limitations on what firms can do with people's personal data, and this relates not only to the legal basis for processing, but also to the principles of the GDPR, which are often overlooked. And by that I mean data minimization, purpose limitation, and privacy by design and default. However, having said all that, I think there are ways of accommodating those objectives when applying competition law and regulation. So data protection and competition law can support and complement each other. If you design a data access remedy in which consumers can make a meaningful choice about giving access to their data under secure conditions to a third party to provide some kind of innovative service, if you can do that, then you can achieve competition and a high level of data protection. And I think when you're thinking about that, it requires regulators to think not only about the platform side of things, but also about consumer behavior and the way that consumers have certain biases, and that needs to be taken into account in deciding any remedies. So, I mean, in a nutshell, unlike my current face colour, which seems to be rather blue, I'm actually not quite the blue about this topic. I think there is a way through it to the advantage of consumers and innovation. And I'll leave it at that.
So Bettina, I was going to jump in earlier, and I do think that we really do have to be careful about how we navigate this. There is no question. There's a question in the Q&A that I think kind of gets at this. Yeah. These digital platforms have provided very, very good and valuable services to consumers at very low prices. Now, people often say that they're not free because you're giving people your data, and that's a price. And I completely accept that. And I think to Vanessa's point, we need to be sure that disclosures and understanding what, so that consumers actually understand what they're giving up when they make use of these free services. But the consumer welfare impact, I mean, I'm just thinking about the pandemic right now. Many of us, have been locked in our homes for the last 7 months, and we've been getting a lot of our goods and services delivered to us, finding them online through, Google or Bing or some other search engine, and getting them delivered by Amazon or some other service, right? And that's been a big benefit to consumers. And we really do have to, I think, make sure that we don't do something that kind of messes up the welfare benefits that consumers get from these services. So there was a lot in all of these comments. I'm just was looking at my notes to try to get through them. I mean, I think we talk about in the U.S. We talk about data, and we've talked about data more as a potential barrier to entry than really as something that gives market power. Although, I think there's some room for that kind of theory. I was actually I thought it was interesting, and I mentioned this before, that the case that was brought against Google wasn't about data, really. It was about distribution and the ability of other search engines to get themselves out to consumers, very similar to Microsoft and what Microsoft did with IE. I actually thought it was fascinating. The market shares in the complaint, if they're right, are amazing. I mean, the Bing not Bing, but Edge, which is IE's successor browser, is now, has less than 20% market share. I mean, it's incredible. And, that's been a change, I think, that probably was in part the result of the Microsoft case and the remedy that was imposed in the Microsoft case, which opened up that market for other competitors. So I think it remains to be seen how the U.S. regulatory enforcement framework develops around data. There's clearly a need for a federal privacy law, in my view. I do think, to Vanessa's point, that we need to be mindful of the barriers to entry that some privacy laws can create. So there's been some discussion in the context of some of what the European Commission's been looking at, and I remember a proposal coming out of India that the American Bar Association commented on, that sometimes if you have the data rules can impede entry and expansion of newcomers, access to data, the ability to transfer it into data across jurisdictions, and can help existing incumbents that already have a lot of data. So I think we need to be mindful of that. And then I guess the last comment I was going to make was about this concept of gatekeepers, and how do we know who's a gatekeeper? It'd be interesting to hear Karen's view on this. How do we identify gatekeepers? What are the metrics we're going to use in Europe to figure out who's a gatekeeper, who isn't a gatekeeper? And are those lists going to change over time? Can you be on the gatekeeper list and then come off of it later if something happens? That seems to me to be a very, very, very important question. Who are we going to be regulating, and how are we going to figure out who that is? Because I think people need some clarity about whether they're going to get swept into this rule if it becomes a rule, or whether there are going to be ways to keep yourself out if your company, for whatever reason, doesn't trigger that. So with that, I will stop and pass it off to whoever wants to go next.
Thank you very much. Any other comments on this point? Actually, I wanted to ask Karen another question in this context, but I think we're actually running out of time, and I still have 3 points here on my program. So perhaps we can move to the next point, which I find really interesting. This is the issue of self-preferencing. And actually, I might add that in Germany, self-preferencing was generally admissible. What we have a new bill that also looks at self-preferencing as a possibly prohibited behavior. So perhaps Stéphanie can say a few things from the EU perspective, and we might have other comments on that. Stéphanie?
Yeah, thank you, Bettina. Can you hear me?
Yes, I can hear you.
Okay, thank you, because there was an echo while I muted my laptop. So yeah, well, as we said, I think the platforms provide consumers with large number of benefits and services. That's what Renata has just said. However, some of them gain such a power that they can prevent competitors from accessing the market or challenging their market power. And ultimately, it harms innovative and small platforms and consumers, which cannot enter the market, but also consumers. I'm turning now to Vanessa, consumers and business users that become dependent with no freedom of choice. And there is what Margaret Vestager said last week, a broad consensus to agree, on the need to intervene in due time. It's now time to intervene, and basically what is illegal offline should be illegal online. It's now the same word, I think, and in the competition policy report, I really recalled the fact that we should better articulate competition policy with sectoral policies and what I said before, but I think it's important: consumer protection, data protection, sustainable industrial also. Fine-tuning is key in this area. We cannot afford having a new regulation that will be too broad without the adequate means, as we said, and we can neither afford having a regulation that will not be future-proof And we are not starting, I think, from scratch, and we should bid on existing markets. I think the aim of the DMA in that sense should be twofold, ensuring that small and innovative companies could access the market despite the market power of some large online platforms, and we should make sure that consumers have or regain a freedom of choice without being dependent. And despite the quality of our European antitrust toolbox, it does not keep pace with the evolution of digital markets and current challenges. The ex-ante regulation, I think, will need to set a framework to prevent some practices that do not comply, and we need to, the main improvement of this ex-ante regulation will be to address the speed of development of digital markets. It is crucial to address this problem before abusive conducts take place and markets tip. And we have also to prevent irreparable harms from occurring, as trying to reverse the situation exposed. So I think basically, and what we know so far, without having much more detail on that, the objective is to establish a set of principles to ensure market contestability, consumer choice, and innovation. A lot of panelists talk about innovation and the fact that we have to safeguard this as well. So some practices may be discriminant or prevent companies from accessing the market, the imposition of own ancillary services, the preferential treatment, where we're talking about that, of own products. And so many listed black practices have to be carefully designed and carefully closely looked at when it comes to defining the new rules that will be necessary. So fine-tuning will be definitely key in that.
Mm. So I couldn't agree more with Stéphanie in the sense that we do have to find a way to act before it's too late, and that has been a constant issue with enforcement and using enforcement as a tool to address these issues. I do think, even though many thought the Microsoft case took forever, I do think in the long run that actually did have an impact, and I think it did change that marketplace for the better. So I also think we shouldn't be too impatient. Enforcement, I think, can have an effect, but clearly if people with market power are abusing that market power in some way, we do need to find tools that allow us to address it. And my own sense is that there has been in a variety of different ways, a feeling of a disconnect between how consumers experience competition and how what I sometimes call the ivory tower competition, world thinks about competition, and trying to bridge that gap so that we are addressing, I still say we, even though I'm not an enforcer anymore, so that we are addressing issues in a way that matches consumer expectations about how they experience competition in the marketplace, including if consumers don't care. So, for example, right, we need to take that into account. So I think these are all good and challenging and interesting questions. The US hasn't been very active on the self-preferencing as such front, so it'll be interesting to see whether or not some of these legislative proposals, whether they come to be, and if they do in some way address that.
Could I just come in on whether consumers care thing, and Vanessa might like to as well, but I think what's really difficult in this space is obviously consumers love these platforms, and they don't necessarily see the slightly complex logical thread that gets you to finding a problem. So, they don't have any concern with Google Android or Google, the practices found problematic in Google Android or Google Shopping, but actually those practices are harming them but it's really not very visible to them. So I think it's a really, really tricky thing, relying, I feel bad saying it, but relying on consumers' own understanding here. And actually it's lovely having Stéphanie on as a politician that understands all this stuff, because in the UK we've slightly struggled with politicians on the same front, because they just see these great innovative things that they're very worried about the content issues around democracy and online harms, but it's taken a really long time to get them to understand the competition issues and why in the end these are really, really important.
Well, it's a little bit like proving a negative, right? Yeah, it can be difficult.
Okay.
If I may come in on Amelia's invitation, I fully agree with what Amelia said. I mean, there's a serious problem of information asymmetry between large players, or in fact probably many digital players, and consumers, which and consumer behaviour, which is logical in many ways and rational in many ways, but not in others, and that is often used by large platforms to sometimes in ways that mislead consumers deliberately. I'm thinking here of dark patterns. Obviously not everyone does that, but so there are ways that you can bring consumers to make decisions they didn't actually want, but they're taken down a path that they don't know what they're misled down that path. But even simple things, without going into dark patterns, things like pre-installation or default settings, those have a huge impact on consumer behaviour without consumers necessarily being aware of it. So in that sense, I would fully agree with Amelia that we can't put all the weight on consumers because they're not aware of some of these things. I also agree with Renata that big tech has been hugely beneficial, but that doesn't mean it can't be improved for everyone at the same time. So and maybe lastly, a last point on Stéphanie's and Renata's point, maybe we've got slower at enforcement in competition. I was thinking about the Microsoft cases, maybe 5 years or so in the US. If I look at Google Shopping, that's 10 years on, and still people think the remedies are not working. So that seems like a long time to have a problem that's not getting fixed from the consumer perspective. Thank you.
Thank you very much. This brings me also to my next question. First of all, I wanted to ask Karen for her opinion about the issue of self-preferencing. And we are already moving to our next issue. And this was, you mentioned it now, the question of timing. And Renata already said the Microsoft case went on forever. And I would like to know the opinion of Stéphanie and Amelia about the question of timing from the regulatory and legislator perspective. So perhaps Karen, would you like to comment?
Sorry, on the market tipping or on the self-preferencing?
Self-preferencing. If you want to comment, you don't have to comment.
No, sure. Well, we were talking about before about the scope of the gatekeeper or scope of the practices that should actually be caught well in the regulation, and how do you actually are in or out. As to self-preferencing, and also and as to the type of practices the ex-ante regulation should actually be looking at, it's in our view, it's actually the recurring harmful business practices. So we believe that that's in particular relevant to self-preferencing, again, of vertically integrated platforms, as I mentioned. And self-preferencing is actually at the heart of some recent competition cases involving digital platforms. So this would actually fit in. And I also believe, in terms of the scope, that also in a speech by the Commissioner last week, it was very much that the aim of the gatekeeper regulation to actually catch the kind of cases and recurring behavior that's already very much on the radar of DG Comp and has already resulted in investigations. So in any case, was what I also mentioned is, the self-preferencing can have detrimental effects for other business users of platforms. And this is also the case in the space of travel. whereby I'm speaking on behalf of Booking.com as a user of Google services and their general search, and how that has evolved and using into the travel space. The other thing, though, we're talking about blacklists and grey lists. It's not necessary that self-preferencing is an abuse practice, even by gatekeeper platforms. So I want to have that nuanced a bit. And there needs to be a bit more of a careful analysis whether the facts of a particular case actually do warrant the presumption of that harmful conduct. For example, when there is a lower priced product that the integrated platform has to offer, as opposed to any other competitors that operate there as well. So that could even be consumer welfare enhancing, and should be analyzed in that sense. And the other thing is, though, if there's a very overly broad application of the limitations on self-preferencing or per se prohibition, that will definitely, well, sort of stifle any action in this respect, and definitely not be in the consumer interest.
So do you want me to come in on the speed issue, which is, I mean, I think that we've already trodden we've already discussed in lots of other lots of other arenas, and a little bit today, about how antitrust can be very, very slow, and that has to be one of the rationales for regulation. But of course, regulation can also be very slow. So I think the real trick of designing this new regulation is going to be finding a way to make it quick and flexible without completely undermining due process, and hopefully getting to as good an answer as possible without being too interventionist and keeping incentives to innovation. All of that is not easy because, as I said, these things are complex. One of the things clearly there's a whole set of things we need to think about. It's a complicated kind of design problem. We need to we need to make sure we don't take ages and ages designating the firms that are actually going to be our large online gatekeepers, because you could easily spend 5 years doing that and never actually do anything to them. You need to think about ensuring that you don't disrupt the levelness of the playing field across those gatekeepers. So, for example, you don't want to treat them very differently in terms of what you're applying to them, because actually you want at least them to be competing vigorously within the framework you've set against each other. It's really good if you can have clear rules, these do's and don'ts, because that can make things speedy, but it's really hard to know how you design them. I'm really excited to see what Brussels is going to come up with, because I quite struggle. And if you look at the 12 that the CMA came up with, actually, if you want to be critical, they've all got kind of caveats. So on the self-preferencing one specifically, it says not to influence competitive processes or outcomes in a way that unduly self-preferences a platform's own services over those rivals. But what then is unduly? Who defines unduly? And where's the burden? Who has the burden of saying something is undue or not undue? Clearly, it's a good idea to have unduly in there, because it's you can certainly imagine types of self-preferencing that are completely reasonable and acceptable. But as soon as you put unduly in, you make life harder for yourself. So actually, how do you get the right balance between these things? More generally, what's the right legal standards? What are the right burdens to be placing? Who should have what burden? What kind of appeal standards should we be having? It's all not straightforward. This is the sort of thing that the CMA is struggling with, and will hopefully provide a bit of clarity on in its advice.
Unduly is actually a term that I know from German competition law, which means basically that you have to look at the balance of interests.
As soon as you're doing that, that's a more complex issue for
Yeah,
a white rule.
So, and by the way, about the timing, I think what you said, I think the German cartel office took years to find that Facebook is market dominant, while every consumer would say, of course, Facebook is dominant. Okay, Stéphanie, would you like to comment?
Yeah, I'll make a short comment since unfortunately I have to rush to another virtual meeting I'm chairing with the Canadian counterparts. So sorry for that. Well, yeah, Bettina, thank you for raising the issue of timing, which definitely is of essence. And in these fast-moving markets, speed will definitely be one of the pro-competitive effect of an ex-ante regulation. When you look at costly and lengthy antitrust procedures, it makes clear that speed is key. Sometimes remedies are not sufficient to get back to normal, and in the meantime, companies and consumers were harmed. But adding that, in addition to that, sorry, and echoing what Amelia said, we have to have quick remedies and quick answers, and also flexible one, easily adaptable to these fast evolving markets and to these very technical and complex markets. So more clarity is needed with a clear and short list of do's and don'ts, and effective remedies as well. I would really favor participative antitrust to design effective, efficient remedies and ensure their enforcement and monitoring. Some of the panelists mentioned monitoring, and I think it's very important to review this over the period of time to make sure they are suitable for the context.
I think we've already come more or less to an end.